This is Colin O'Keefe here for LXBN TV. The Affordable Care Act's contraceptive mandate is off to the Supreme Court. That much has been decided. But we're still seeing news on the controversial issue as the Act's mandate has been halted until we see that Supreme Court ruling, with one of those injunctions coming from the Sixth Circuit Court of Appeals. Joining me now to explain what this means and whether or not it will have any bearing on the Supreme Court's ruling is attorney Steve Delchin. He is with Squire Sanders and he is author on the firm's Sixth Circuit Appellate blog. Steve, first, can you explain the basics of the Sixth Circuit's actions here? What's the backstory on this?
Hi, Colin. Happy 2014, and what a year it's going to be for several high-profile lawsuits in the federal appellate courts. Here's the backstory on the latest skirmish in the continuing battle over Obamacare. As we reported on my firm's blog, the Sixth Circuit on the last day of 2013 granted a motion filed by Michigan Catholic Conference and Catholic Family Services to halt the so-called contraception and abortion mandate under the Affordable Care Act, also known as Obamacare, that went into effect at midnight last Wednesday. Now, as we've discussed before, this is the recent mandate put in place by the Department of Health and Human Services that requires employees to cover contraceptives and abortion-causing drugs in their employee health care plans. The plaintiffs in the Michigan case are arguing that the mandate is a direct attack on their religious freedoms because it forces them as Catholic entities to violate their religious beliefs by having to provide and pay for contraceptives and abortion drugs. And the penalty for noncompliance could be literally thousands of dollars daily in fines. In their complaint, the plaintiffs are claiming that the mandate violates their rights under the First Amendment Free Exercise Clause, as well as their rights under the Religious Freedom Restoration Act. Now let's be clear about what the Michigan lawsuit is not about. The plaintiffs point out that their action is not about whether Americans have a right to contraception or abortion-inducing drugs. Indeed, they concede that the federal government can provide them. What they say is at stake here is the freedom to practice one's religion without government interference. Now, Colin, I think the last time we spoke, there were about 40 lawsuits making their way through the federal courts challenging the contraception mandate. That number is now up to 91. And in fact, on New Year's Eve alone, courts in no less than 4 cases issued temporary injunctions against the mandate. That includes a high-profile decision by U.S. Supreme Court Justice Sonia Sotomayor, who blocked enforcement of the mandate against a group of nuns called the Little Sisters of the Poor. The nuns were actually in the middle of their New Year's Eve celebration with a group of low-income seniors when they found out about the favorable ruling in their favor. So without a doubt, the Supreme Court will be busy in 2014. There's 2 legal challenges to the mandate presently before the High Court. So we can expect to see oral arguments sometime in the spring with final decisions by the end of June.
I see. So with what the Sixth Circuit has done here, and then, of course, that action by Supreme Court Justice Sonia Sotomayor, does this give us any kind of inclination about which way the Supreme Court is going to go, or is this really a standard procedure here?
Well, the actions by the courts on New Year's Eve are not really standard procedure. The entry of an injunction pending appeal is an unusual event. So what the courts have done in these cases is certainly significant. On the other hand, I don't think you can really draw any conclusions from the temporary injunctions. First, you need to remember that the Supreme Court injunction was not a decision by the full court. It was just a ruling by Justice Sotomayor in her role as the circuit justice for the circuit where the case was filed. Her ruling on New Year's Eve also does not necessarily indicate how she plans to rule on the merits. She may have just granted the stay simply for purposes of maintaining the status quo so the full court can hear the rule on the matter. And it's the same thing with the Sixth Circuit decision. The motion for an injunction pending appeal was actually heard by a motions panel of the Sixth Circuit, and it's very likely that a different 3-judge panel of the court will ultimately rule on the merits of the appeal. If you really want insight on how the Supreme Court may rule, consider the fact that the U.S. throughout its history has always been protective of religious liberties, and then add to that fact that the Supreme Court as of late has been very protective of religious freedoms. So this, more than anything, could tip the balance in favor of the plaintiffs, but it is still several months before we find out. So, bottom line, stay tuned. We'll, of course, be following all the latest developments in the continuing legal battles over Obamacare and the contraception mandate.
Definitely. It's going to be a fascinating story to watch this year. Definitely one of the biggest legal stories in 2014. Once again, that was Steve Delchin of Squire Sanders for his analysis on this case. Be sure to visit sixthcircuitappellateblog.com. And of course, if you're not already watching us here on our side on LXBN, be sure to visit LXBN.com, where you can find curated commentary from the world's largest legal blog network, along with hundreds more of these LXBN TV video interviews. Thank you for joining me today, Steve.
Thanks, Colin.